Judge Angerin just responded to Trump's lawyers by email. The email is short. Here it is in full. You have failed to explain, much less justify, any basis for a stay. I am confident that the appellate division will protect your appellate rights. That's it. That's his answer to Trump's request for 30 more days to figure out how to pay $464 million denied. Now, before we go any further, think about what that situation actually feels like. Imagine you went to a restaurant. You ordered the most expensive things on the menu for years. The bill came. It's enormous. And now you're sitting there asking the waiter for more time. And he looks at you and says, "You had the meal. You owe the money. I'm confident the manager will sort out your rights. Pay up." The analogy isn't perfect. Trump isn't a guy who ate a meal and can't afford the check. The reality is actually more complicated than that, and more consequential. But the core feeling that analogy captures is exactly right. There is a bill. It is very large. And the person who presented it just told you in 2 sentences, "I'm not giving you more time. Figure it out." That's what happened on February 22nd, 2024. And today we're going to break down exactly what it means. The legal mechanics, what it means for an ordinary person watching this unfold, and what's coming in the days ahead. The judgment, what Trump actually owes and why. On February 16th, 2024, a New York civil court handed down the largest civil fraud judgment ever entered against a private American citizen. The case was about a decade of deliberate misrepresentation. Trump inflated the value of his properties when he needed loans, making his assets look bigger so banks would give him better terms. When tax time came, those same properties were reported at lower values. The fraud was systematic. The court found it was intentional. The core penalty, $354,868,768 in disgorgement, not a fine. Disgorgement means you hand back what you wrongfully gained. The court determined that number represented the illicit benefit Trump obtained over years of fraud on his financial statements. Added to that, $98.6 million in prejudgment interest, the interest that accrued from when the fraudulent conduct began through the end of the trial. Trump's portion alone, approximately $454 million. Add in Eric Trump, Donald Trump Jr., Weisselberg, and McCanney, and the total judgment entered by the court clerk on February 23, 2024 was $464,576 down to $30.62. The moment that number hit the official record, the clock started. The clock, $112,000 a day, and rising New York's statutory interest rate on civil judgments is 9% annually. On $454 million, that's roughly $40.8 million per year. Break that down to a daily figure, and you're looking at approximately $112,000 every single day, every morning. Whether Trump is at a rally on Truth Social, at a golf course, $112,000 more added to the bill. Trump's lawyers called posting the full bond impossible. Letitia James said if he doesn't pay, she will move to seize his assets. And Angerin, the judge who spent months watching Trump's lawyers make arguments he found unpersuasive, told them what he thought of their stay request in one sentence. But in order for Trump to stop that clock, he had to post bond, which meant putting down the entire amount, $464 million plus interest, plus what surety companies typically require. Every day he failed to do so, another $112,000 was added. That is a lot of money, and there was not a lot of time. And on February 22nd, in a short, very terse email, Judge Angerin denied Trump's request for more time. What this means for an ordinary person. Before we go deeper into the legal mechanics, let's pause here, because if you're watching this from outside America, or you're someone who isn't a lawyer or a financial analyst, you might be wondering, why does this matter to me? Here's why. What Trump was found liable for, inflating asset values when it benefits you, deflating them when it doesn't, is not some exotic financial crime that only happens at the billionaire level. It happens in property deals, in business partnerships, in loan applications everywhere in the world. Someone tells the bank their house is worth more than it is to get a bigger loan. A business owner understates assets to pay less tax. The mechanism is the same, only the scale is different. This case matters because a court looked at a decade of that behavior, at the highest level, with some of the best lawyers money can buy, and said, no. The numbers were wrong, you knew they were wrong, and now you're giving the money back. For an ordinary person, that matters because the same principle applies at every level. The question a court is really asking in a case like this is simple. Which number is true? And when the answer turns out to be neither, when the numbers changed depending on what was convenient, the system has a response. The second thing this means for ordinary people, accountability isn't just about the guilty party, it's about trust. When people see that a system actually works, that a clock starts, that interest runs, that assets can be seized, they trust that system more. And societies that have functioning accountability systems attract investment, protect citizens, and function better at every level. When accountability only flows downward, only toward those who can't afford to fight, that trust collapses. The civil fraud judgment, every step matters. Now let me explain exactly what's happening and why each step in this process matters. The $354,168,768 in disgorgement was handed down on February 16th. That's not the final number Trump owes. It's the core amount of illicit gains the court determined he obtained through fraud. Added to that is the $98.6 million in prejudgment interest, accruing from when the fraud began through the end of trial. Combined total for Trump personally, approximately $454 million. Add in the co-defendants, the full judgment entered by the clerk on February 23, 2024, is $464,576, $230.62. That number then begins accruing post-judgment interest at New York's 9% statutory rate. On the full Trump portion, that works out to approximately $112,000 per day. By August 2025, without any payment, the total would approach $500 million. The clock runs during the appeal. The interest doesn't stop while the courts consider the case. The 30-day stay Trump's lawyers requested was not asking for a payment reduction. It was asking for more time before enforcement could begin, specifically to arrange financing for the bond. New York civil law provides an automatic stay on collection actions if Trump posts a bond covering the full judgment amount. So the process is judgment entered, 30 days, bond posted, automatic stay, appeal proceeds. If Trump doesn't post the bond within 30 days, Letitia James can begin executing against his assets. Engoron's dismissal of the stay request was both legally precise and, given everything that had happened in his courtroom over the previous 4 months, final. Trump had violated gag orders. He had given testimony Engoron found not credible. He had stormed out of the courtroom. His lawyers had made 10 unsuccessful trips to the appellate division during the trial itself, and now they were asking for more time to deal with the consequences of the judgment, arguing that their client, who claimed to have hundreds of millions in cash, needed 30 days to figure out the money. Engoron's response: no, go to the appellate division. I'm confident they'll protect your rights. Letitia James. What she said and what it meant. Letitia James made one of the most striking statements by a state attorney general in recent memory. She told ABC News directly, if Trump does not have the funds to pay off the judgment, her office would seek judgment enforcement mechanisms in court and ask the judge to seize his assets. This is not a vague threat. It is a specific procedural description of what happens when a civil judgment isn't paid. The judgment creditor, James's office, representing the people of New York, files to enforce. That process can include placing liens on real property, garnishing accounts, and ultimately executing on assets through forced sales. The properties most obviously at risk: 40 Wall Street, Trump Tower, Trump golf courses in New York. The ones that New York courts have direct enforcement jurisdiction over, the ones that had been the foundation of Trump's public identity for decades. James's statement served multiple purposes simultaneously. It was a legal warning that collection would proceed. It was a statement of principle. There cannot be different rules for different people. And it was a pressure tactic. The more publicly Trump's potential asset seizure was discussed, the more motivated his team would be to find the bond rather than let the properties be touched. That principle, no different rules for different people, is not a political statement. It's the bedrock of any functioning legal system. And it's the reason people across the world were watching this story, not because they care about American politics specifically, but because that principle either holds or it doesn't. And when it holds, when a court actually enforces it at the highest level, something real happens to the credibility of institutions. The bond crisis, what impossible actually meant, Trump's lawyers went to the appellate division and filed a motion saying the requirement was genuinely impossible. To back that up, they had approached over 30 surety companies. Every single one declined. A surety company that writes a bond essentially promises to pay the judgment if the defendant can't. They're betting that either Trump wins on appeal or that Trump has sufficient real assets to cover the debt. Given the uncertainty about Trump's actual liquid assets, given the court order restricting business transactions, and given the sheer size of the obligation, the companies declined. This is not political. This is financial risk assessment. 30-plus companies looked at the numbers and said, we're not willing to bet $560 million on this. Now consider what that tells you. Trump publicly claimed to have $400 million in cash on hand. His lawyers simultaneously told the court that posting the bond was impossible. Both of those things cannot be fully true. Either he has the cash, in which case post the bond, or he doesn't, in which case the impossible claim is accurate. The financial world, in the form of 30-plus surety companies doing nothing more than their jobs, appeared to believe the lawyers more than the candidate. For an ordinary person, that gap between what someone claims to have and what the market believes they actually have is the most revealing number in this entire story. The resolution and what it cost the appellate division did not immediately grant a stay. The full bond crisis, the 30 surety companies refusing, Trump's lawyers filing the impossibility motion, the March 18th deadline approaching, played out across weeks. On March 25, 2024, the appellate division reduced the bond requirement from $464 million to $175 million. a 62% reduction. The court accepted that the full bond was genuinely impossible and found a number that was feasible. Within hours, Don Hankey, a wealthy ally from the car loan business, posted $175 million in cash collateral through Knight Specialty Insurance. Bond posted. Automatic stay in effect. Letitia James's immediate enforcement paused. Appeal proceeding. Crisis resolved. At the last possible moment. But count the days. February 22nd to March 25th. That's 31 days. At approximately $112,000 per day, roughly $3.47 million in additional interest had accrued during the bond crisis itself. Money added to a judgment that already represented a decade of illicit gains, simply because no surety company would write the full bond. The financial cost of the delay wasn't just time, it was money. And that money accumulated because the market didn't believe the $400 million cash claim. What's coming? The days ahead. This story is not over. As of early 2026, several critical threads remain unresolved. In August 2025, the appellate division vacated the core $354 million disgorgement penalty on Eighth Amendment grounds, finding it constitutionally excessive. A significant partial victory for Trump. But Letitia James has appealed that ruling to New York's Court of Appeals, the state's highest court. That appeal is ongoing. Whether the $354 million stands, gets reduced, or is eliminated entirely is still being decided. And here's the thing about the interest. Regardless of what happens to the principal, the interest that accumulated throughout the entire appeal period, every day from February 23, 2024 onward, remains a live issue. When the Court of Appeals rules, the full numbers will need to be sorted out. What does this mean going forward? If the $354 million is ultimately thrown out on constitutional grounds, it raises a serious question for future cases. How do courts impose meaningful financial penalties in large-scale fraud cases without crossing constitutional limits? The precedent matters not just for Trump, but for every white-collar fraud prosecution that follows. If James wins her appeal and the penalty is reinstated, the message is equally clear. The interest clock runs the entire time your appeal is in progress. The longer you fight, the more you owe. There is no way to pause the financial consequences while arguing about the financial consequences. Either outcome settles one thing permanently. The mechanism works. A judgment was entered, a clock started, enforcement was threatened, a bond was eventually posted. At every step, the system moved. Imperfectly, slowly, but forward. For ordinary people watching systems of accountability around the world, that movement matters more than the specific dollar amount. Back to those two sentences. Now let's come back to where we started, because Angaran's email deserves a second read, more slowly this time. You have failed to explain, much less justify, any basis for a stay. 2 steps. Explain, meaning tell me the facts and circumstances you're relying on. Justify, meaning show me why those facts legally entitle you to what you're asking for. Angaran is saying Trump's lawyers didn't do either. They didn't explain the basis, and even if they had explained it, they didn't provide the legal justification for why those circumstances warranted a stay. Trump's lawyer's argument was essentially, this is a very large judgment and our client needs time to process it. That is an explanation of the situation. It is not a legal argument for why a stay should be granted. There is no rule that says large judgments automatically get paused. The existence of an appeal right doesn't automatically carry a stay. You need to make a specific legal argument for why the specific circumstances justify pausing enforcement. They didn't make that argument, and the judge said so, in one sentence. I am confident that the appellate division will protect your appellate rights. This is Angaran directing Trump's lawyers to the correct forum, not as comfort. Not as sympathy, as a procedural instruction. My job is done. That court handles what comes next. Go there. After 4 months in that courtroom, after the gag order violations, the testimony he found not credible, the storming out, the 10 appellate division trips during trial, Angaran responded to all of it with the rhetorical equivalent of a closed door. Not today. Next court. That efficiency, 2 sentences after months of proceedings, is itself the statement. I have nothing more to say. The judgment stands. The clock runs. The rest is not my matter. The restaurant check analogy from the beginning of this story, the one that isn't quite right, actually gets at something true anyway. What happens when you can't pay the check and it's a very big check? In Trump's case, the answer turned out to be, your ally from the car loan business puts up $175 million in cash collateral. The appellate division cuts your bond requirement by 62%, and you post the bond at the last possible moment. But for 31 days, that answer wasn't obvious. And the question, can he actually pay, was hanging in the air. Here is a man who built an entire public identity on wealth, who told the world for 40 years that he was extraordinarily rich, who used that claimed wealth as the foundation of everything. And a court asked, show us the money, post the bond, prove the wealth is real. And the market, 30 companies doing nothing more than assessing risk said, "We're not sure it is." That's not a political statement. That's a financial evaluation. And it's the most honest answer anyone gave to the question the restaurant analogy was trying to ask. Angeren's two-sentence email is the document that started those 31 days. And on February 22nd, 2024, when it arrived, the crisis was just beginning. The clock was about to start, and nobody knew how it would end.